Good morning. It's an absolute pleasure to be here in Bangalore, particularly so because I grew up in Delhi, spent 5 years there in my childhood, and so I'm returning here to India for the first time in 14 years. So I'm absolutely delighted to be here. I'm less pleased about having to speak immediately following Ilya, partly because he got first dibs on topics, and he's also a lot older. More experienced than I. So what I've done is I'm just going to focus on a few key issues in a little more depth. There is obviously overlap between our fields, but Ilya, feel free to pitch in if some of the topics that I'm talking about apply or don't apply to your field. So just by way of background, I'm a microbiologist by training. My practice area is principally in the area of biotech, with some work in the pharmaceuticals and medical device field, and I'm based in our London office. Ilya's already touched upon our success rates and our experience in contentious proceedings. The only thing I would add is that I think our knowledge and experience in attacking and defending patents means that that experience really permeates the rest of our practice, because we know where the weaknesses of patents lie. So when it comes to drafting, we know how to draft very robust specifications that will withstand post-grant attack, and we'll build in appropriate fallback positions that mean we have space to maneuver if we are challenged post-grant. Also during prosecution, we're just able to avoid the pitfalls in prosecution. So I'm going to talk to you today first a little bit more about third-party observations. Ilya's already mentioned their utility as a cost-effective measure and sort of as your first sort of starting point in an offensive strategy. I'm then going to turn to EPO oppositions and discuss claim requests, inventive step, and added subject matter. So third-party observations are very cost-effective because there are no official fees to be paid. There's no huge submissions to be prepared. In fact, the more concise your arguments, the better, because an examiner is not going to wade through 30 pages of arguments. If you can, I would recommend, in my experience, a page and a half, 2 pages max is probably all you want. You want to be short and punchy and concise, and they can be used to really great effect. You can file third-party observations in the international phase. Now, I haven't done this yet, but it's something that clients of mine will be very interested in. We routinely monitor competitors of my clients' PCT publications, and we find that whilst the examiners in Europe or the US might find the relevant prior art, then other jurisdictions where maybe the searching isn't so good might not throw up the correct documents that we really want the examiner to be aware of. So filing these and putting them on the file in the international phase means that all the national phase examiners are going to have these documents to hand. On a slightly more devious, maybe aggressive sort of strategy, it's also worth bearing in mind that you can really increase somebody's IDS burden. I've heard in a talk yesterday that, and speaking to local attorneys this week, that the information disclosure requirements before the Indian Patent Office are really quite high, as are they before the US PTO, of course. So if you can add to that burden in the international phase by filing documents, possibly even in a foreign language, which is going to require translation, you're just going to make life difficult for the applicant. You're going to increase their costs. They've got to review the documents, and they've got to file them in IDSs. Before the EPO, Ilya's already talked about them. Again, I concur with him that they can be extremely effective if you don't want to go into opposition proceedings because of cost, or maybe because you don't want to maybe because it's just, commercially not important enough for you to spend that money. The interesting thing is that you can file third-party observations during examination proceedings, but also during opposition proceedings. Now, this is of particular interest if you've, by some means, if you've missed the opposition window that Ilya was talking about, the 9-month period where you can file an opposition. If you've missed that window and you want your voice to be heard, then this is an opportunity for you to put your submissions forward. The OD, as well as the examining division, they are compelled to consider and comment on these observations. So it's an excellent way to be heard. It doesn't make you party to the proceedings. You will never enter into the proceedings as a party. But nevertheless, they're really an effective measure in certain circumstances. My first point in regard to EPO oppositions are claim requests. Now, these are of principal importance if you're the patentee. Your main request will be your claim set with a broader scope, and then you'll have your fallback positions in the way of auxiliary requests, which will slope down 1, 2, 3, 4, 5, 6. And it's really important that you get all your ducks in one row at the earliest possible opportunity. What we've seen in recent times is that both the opposition division and the boards of appeal are clamping down on late filed requests. So if you don't get your arguments in early enough, and Ilya's already touched upon this, then you're going to really face an uphill struggle justifying to the opposition division or the boards of appeal why these requests should be admitted at a late stage in the proceedings. So I'm going to talk a little bit about things you need to consider as a patentee, as well as considerations if you're the opponent. As a patentee, again, you need to make sure that all your claim requests are on file at the earliest possible opportunity, whether it's in response to a notice of opposition, and at the very latest at the final deadline for filing further submissions, which is usually 1 month before the oral proceedings. You need to make your claim requests responsive to objections raised. This is not an opportunity to tidy up your claims or your description or in other way amend your case or your patent. You can only amend in response to specific objections, and you need to raise these as soon as possible. So if an objection requires an amendment, you need to enter that. For example, you're going to face a real uphill struggle convincing a board of appeal that they should admit a claim request when it's an objection that was first raised during opposition proceedings. So if you do come to the point where you have to make requests on the day, it's important that you justify why you're making that amendment. So again, if you're going to face an uphill struggle, if this is an amendment or a claim request responsive to an old objection. Again, a lot of boards will vary in how they deal with all sorts of matters, including claim requests. Some are more permissive, some are far more strict. And again, our experience means that we know the boards, we know their foibles, we know that Board X is a stickler on added matter. We know that Board Y is really quite happy for you to bring claim requests to the table at a late stage. The final point I'm going to make is that you need to appeal proceedings are what it says on the can, is that they are a review of the first instance proceedings. So a Board of Appeal is very unlikely to want to cover new ground that hasn't already been looked at by the opposition division. So if you want a claim request to be considered in the appeal proceedings, don't withdraw it during opposition proceedings. They will not automatically form part of the proceedings, appeal proceedings, so you need to be aware that you should under no means withdraw those requests. From the opponent's perspective, your job is, as a representative and as the opponent, you want to prevent the patentee from having too many bites of the apple. So you want to try and limit the opportunities they have to file claim requests. If you start from the basis that an opposition division is only going to allow a finite number of claim requests because they're just things have to come to an end at some point, they want to go home, then you might want to consider as an opponent, and I'm doing this on a case now, where I'm reserving some arguments for oral proceedings in the hope that if they're successful, it'll force the patentee to make amendments on the day, file new claim requests, and therefore hopefully use up some of his let's say his goodwill before the opposition division. So when it comes to really substantive matters where I think the patent is the weakest on inventive step, that come then I'll be magnanimous when they're making these claim requests initially for added matter and say, well, okay, okay, very well, and come across as very reasonable to the opposition division. But then when it really counts, when I really don't want them to have anywhere to manoeuvre, that's when I'll say, well, actually what, they've had so many chances today. They've already had X number of claim requests, and it's about time that you put your foot down and didn't allow these in. The next topic is inventive step in opposition proceedings. As a lot of you, or probably every one of you, will know, the EPO utilises quite a rigid approach to the assessment of inventive step, and it's the problem and solution approach. And the higher you go from examining division to opposition division or appeal, the more stringent they come in the application of the problem and solution approach. So the first step in problem solution is to identify the starting point, your closest prior art document from which your inventive step attack or inventive step argument starts. So the selection of this document is critical, whether your opponent or indeed the patentee. Now, in the life science fields, biotech and chemistry, there's often an argument. You prove non-obviousness by way of data. You have data showing that you have better binding specificity or increased sensitivity. I don't think it's quite like that in your field. So that's why in the sort of the life sciences field, it's really the identity of this document and the availability or non-availability of data is a really important consideration. As a patentee, if you have comparative data over a particular document, then that's really in most cases you would want to select that as your closest prior art document. The reason being is that, as I've mentioned, is that having an advantage and improved effect is extremely persuasive before the EPO in arguing non-obviousness. So that's something I mentioned earlier, where I think where our experience in oppositions and appeals flows into the rest of our practice areas, including drafting, because there's case law that states that if you identify a closest prior art document in your patent specification, that document should represent the starting point for the assessment of inventive step. And boards of appeal will follow that unless they can identify something that's technically more relevant. So if you at the drafting stage already know of a prior art document and you already have data to hand, then it's a good you have very little to lose of actually identifying that and calling that out in your specification, because that makes the burden on the opponent much higher and makes his job a lot harder in opposition. As an opponent, you're obviously on the flip side. If there's data on file, if you think that the patentee can generate data against a particular document, then you want to steer away from that document. You might not even want to file it if it isn't already in proceedings. If it is in proceedings, then you definitely want to move the argument away from that document, call it D1, and try and focus on D3. as an opponent, you also, I mean, this is, I don't think I'm telling you anything new here. Good advocacy means that, you know, you might want to decide when you show your card. So when you're filing your notice of opposition, you might want to run several inventive step attacks. You might want to start with an inventive step attack from D1 and D3 and D7. You can go a step further and let's say focus your inventive step attack in your notice of opposition and on D1, whereas in actual fact you're really planning on starting your inventive step attack on the day from D7. So that we've used that to good effect on more than one occasion, where we sort of mask the identity of the document that we're going to attack from. And that means the patentee is on the back foot, because they would have spent most of their preparation on focusing on D1. And it comes to, then on the day, you know, at the end of the day, after you've gone through added matter, novelty, possibly sufficiency, then they come to inventive step at the end of a long day where they're tired, and then all of a sudden they get hit with something they weren't expecting. That can be really, really beneficial for you. The final point I'm going to talk about is added matter, and